The next case then is David Fulton versus the State of Florida.
Your Honor, since Mr. Johnson didn't show up, can we get his 15 minutes?
Let me think about it and get back with you. Yes, sir. You're ready to go.
May it please the Court. My name is Dean LaBeouf. I'm here with my co-counsel and partner, Eddie Bauer, on behalf of the appellant, David Fulton. I'd like to reserve 3 minutes of my time for rebuttal.
Yes.
This is a single-issue appeal. It is our contention that the trial judge unintentionally committed fundamental error when he used his own non-medical evidence and opinions during his deliberations. By considering this non-record evidence in his deliberations, he deprived Mr. Fulton of due process of law. In essence, the trial judge, by considering outside evidence in his deliberations, became an additional witness who was not subject to cross-examination. Consideration of this outside evidence on its own is fundamental error and entitles Mr. Fulton to a new trial. The error here, however, is compounded because the outside evidence considered by the trial judge was also not scientifically or medically accurate, thereby mandating the need for a new trial. As conceded by the State in its answer brief, the facts in this case are not in controversy. Everyone agrees that the alleged victim, Michael Atanasowski, who, with the Court's permission, I will refer to as Michael today because of the difficulty of his last name, attacked the defendant, David Fulton, because Mr. Fulton was seeing Michael's ex-girlfriend. Michael testified that he went to a party and found his girlfriend passed out in the passenger seat of Mr. Fulton's car, and then he saw hickeys on Mr. Fulton's neck. Michael admitted that this made him mad and he wanted to fight.
Let me ask you this. We tell juries all the time that they're to exercise and use their common sense in evaluating the testimony of evidence. It almost sounds like you're saying that if an expert testifies to something that doesn't make common sense, the jury is bound by the expert's opinion unless the other side puts on another expert to contradict what was said. Why isn't that the position you're taking? And I would say, why isn't that incorrect?
Well, because, Your Honor, as we look at the record in this case, what we have is, and I think we have to put it in context, the trial judge in this case heard our motion for appellate bond. And we made this argument, or preliminary stages of this argument, to him during the appellate bond, and he responded in the record by saying, so you're telling me I have to put my years of experience as a personal injury lawyer aside in considering a case. And that's exactly what he needed to do, because as you look at the record in this case, we see that the trial judge did exactly the opposite, that he, at the early stage of the case, volunteered the fact that he had served as general counsel for one of the involved hospitals in the case. He engaged in dialogue and exchange with the trauma surgeon and went into an extensive discussion about traumatic pneumothorax. He got into a discussion with Dr. Foudy, the brain damage expert who testified in the case, and queried him about a myth or a theory as to whether or not a right-handed person would develop left-handed qualities in their brain. And then
you have to admit that at some point, any fact finder, whether it's a juror or a judge, is going to rely on things that they know. I mean, if somebody came in and testified that the defendant said it was raining, and I know that's not true because it never rains in the summer in Florida. If that was the expert's testimony, I know that it rains in the summer of Florida. Am I supposed to ignore that because that's my personal knowledge?
Well, Judge, I'm glad that you brought that up because in People v. McDonald, the Illinois Supreme Court considered that issue where the trial judge, in contradiction to the conflicting evidence, stated that he knew that at 4:45 in the morning that it was quite bright in the morning during that time of year. And the appellate court reversed him because they said...
Because they knew it wasn't.
Well, they said it may or may not have been, but to consider extraneous evidence, to consider outside evidence in deliberations is fundamental error. and is improper. And what we have in this case, when we apply the backdrop, is the trial judge's own interjected expert opinion in this case.
What about the Dr. Fouty? Did his testimony explicitly state that the judge's opinion was completely wrong? Were they inconsistent?
There was no chance. Because, yes, two things. Yes, his opinion was that this young man sustained a closed head injury.
But did he say when it occurred, since there was evidence that trauma had occurred to this young man before?
Yes, he opined that the young man had had a prior brain injury, that his symptoms had resolved, and that this new brain injury was an injury consistent with the location of the blow. And that's the incorrect scientific component of the trial.
On cross-examination, though, didn't he say that he could not say within a reasonable degree of medical certainty that it was this incident that caused the brain damage as opposed to the prior incidents?
It wasn't that clear, Your Honor. What he said was...
It was clear when I read it.
Well, what he said was that the trauma had caused a brain injury, and I think the testimony was that he couldn't distinguish, the exact components or nature, but he did find that there was a brain injury from this insult. But distinguishing, individual characteristics or components, if you will, in other words, he couldn't state completely and clearly whether or not this was an aggravation to a pre-existing condition or whether or not this was in itself, an independent new brain injury.
Okay, and in rejecting that, there were a number of things the trial court said, correct? But the first one was, I don't believe, based on what I've heard, that the doctor knew very much about the facts of the case.
Well, what he did is he found that...
That was one of the things he said, correct?
He criticized some of the underlying facts of the case, but the trial court's opinion, the substituted opinion or the conflicting expert opinion that he provided didn't have anything to do with the controversy in the facts. What he said was, at page 352 of the record, one would expect that a person that was hit from behind with sufficient force to cause brain damage would have swelling, would have redness, would have bleeding. There was absolutely no record evidence that that type of manifestation was required for a closed head injury. It was contradictory to Dr. Fouty's opinion.
Let me ask you this question. What was the appellant charged with?
The appellant was charged with aggravated battery with a weapon causing an injury.
Didn't he admit that he stabbed the young man multiple times?
He never testified, but there wasn't really any controversy in the case.
And there's no doubt the young man was injured and taken to the hospital.
Correct.
And there's no doubt that he did it because there were eyewitnesses. Is that fair?
Correct.
What was his defense? Was his defense that I was psychologically or physically impaired because of the blow to my head? His
defense was that this unprovoked attack caused him a very serious injury. The attack continued.
So my question was his defense that he was impaired?
No, the defense was that he sustained a permanent serious injury as a result of the attack, which made it a felonious attack, which justified the use of defense.
His defense was self-defense?
Yes, sir.
That is, I got hit with a fist, and it was okay for me then to stab him with a knife.
I got hit with a fist that caused serious injury and then was continuously being attacked with no end in sight, so I used self-defense to overcome.
Wasn't the facts that they were involved in hand-to-hand combat, that is, two boys in a fist fight, and then one pulled a knife and stabbed the other several times?
Well,
were those the facts?
That's part of the facts.
Well, was the other guy armed with a knife or with a board or with a brick or with a pop bottle?
There was no evidence to indicate that the assailant had anything other than his fist.
The two guys involved in mutual combat, fist fight, and one guy pulls a knife and stabs the other.
Judge, I apologize, but I think that...
Well, correct me. Are any of those facts wrong?
Yes, because it wasn't a fist fight, it was an attack. It was an unprovoked attack.
Well, wasn't that an issue of fact? I mean,
no.
There were certainly witnesses that said that your client got up after he was hit from behind and charged the...
One witness said that he got up and charged. The multitude, but all witnesses...
That's all it takes, isn't it?
Yes, sir, but all witnesses agreed that he was dazed, that when he was knocked down between 10 seconds and 2 minutes, that when he started to come to, he said, "What happened?" "Where am I?" repeatedly, and that was uncontroverted. And that the assailant continued to, as the attacker, and was saying, "Get up, this isn't over." And as soon as he got up, the assailant admitted that he came forward to continue the attack. That's uncontroverted. And, so what we have is a clear, uncontroverted record where our client received cognitive injuries. He had a cognitive deficit after the initial attack, and that the attack continued, and that no bystanders rendered any assistance or provided him with any help or aid, and the only time anybody intervened was when he started stabbing the defendant and started to gain equal ground in the fight, and that's when it was broken up.
Did he have a duty to retreat at all since he wasn't winning the fisticuffs?
Well, there was evidence that when he came to, that he stepped back. And there's conflicting evidence on that. But there's evidence that he stepped back, but the assailant continued to say, and this is uncontroverted, get up, this isn't over," with his fist balled, ready to fight continuously.
Two guys in a fight over a girl, a fist fight over a girl, and one pulls a knife. Is that what you're saying?
No, I'm saying that there was an unprovoked attack resulting in
Okay,
very
let's say
serious
he got
injuries.
cold cocked, got knocked down. You know what that means?
Yes, sir.
Okay. Let's say he got knocked down and was surprised, was dazed, got up, and then engaged in a fist fight. And your argument for self-defense is that?
My argument for self-defense is that it was more than that he had serious injuries at that point, with the unrefuted evidence that he had brain damage as a result of that first blow, and that the attack continued, and he had a right to use deadly force to prevent ongoing, permanent, serious injury.
You need both the injury and that the attack continued, is that correct?
I don't think, yes, because certainly it would be...
We have to take the evidence in the light most favorable to the appellee, correct?
Well, this is a de novo review because of the allegation of fundamental error.
It's not de novo review of disputed factual issues, is it? How do we de novo review a factual issue?
No, it's not.
You've got 3 minutes.
So on the factual issues, we have to take them in the light most favorable to the state, correct?
Yes.
And if we do that, we have to take as given that he got up and charged the guy, because there's at least some evidence in the record that says he got up and charged the guy, right?
Yes, sir.
Okay.
I'll reserve the remainder of my time.
You've got 2.5 minutes, sir.
May it please the Court, my name is Carmen Corrente. I represent the State of Florida and the Attorney General in this case. Continuing on in the pages of the record that were earlier read by appellant, the trial judge found where this thing went awry is when Mr. Fulton reached into his pocket, or some part of his body, pulled out a 9-inch knife and stuck it in this man incessantly until he backed away or someone separated them in the fight. I don't find that he had any reaction consistent with a head injury. In fact, he told the young lady who testified yesterday that he stabbed the man. He apparently was able to drive himself away. There is no surrounding evidence, if you will, that are consistent with a head injury. We don't just have an expert witness here who says there was a head injury positively because he doesn't have a time. He doesn't have the time of the event. There were prior injuries. There could have been any number of injuries after this occurred and before the testing was done. So we have an expert who opined there must have been some kind of injury, but we have factual circumstances surrounding this where he was able to secrete the knife, drive himself off to the Waffle House, and do many other things that show that he was cognitive and aware. The judge says, my factual conclusion, that there is no doubt in my mind he did not receive a head injury. His exercise of the use of the weapon was far beyond the force he was legally entitled to use. I'm finding him guilty. There's ample record evidence to support that finding because the judge used surrounding circumstances. All of the witnesses, although there were some differences, we don't even know if perhaps the kids beat up this guy after this victim was taken to the hospital. We
Let
don't know
me
what
ask,
happened after the
let me ask you this. The judge's comment that one would expect that a person that was hit from behind with sufficient force to cause brain damage would have swelling, would have redness, would have bleeding. First question is there any evidence in the record to support that conclusion? The second one, is it your position that that comment from the judge, although improper, was irrelevant to the determination, or that it was perfectly proper and or that there was any support in the record for it?
In answer to both parts of that question, I think it was based upon common sense. The judge cites the common sense, therefore I think it was proper. Now, we know in whiplash injuries and other injuries, or I guess it's known in the civil realm, not my expertise, but that you can have some kind of injury and that it's not reflected by swelling and redness. The judge in this case saw that it was a fist that hit and didn't see anything alongside that would show that he was damaged to a certain extent. And let me carry that a little bit further. If it was improper, it's difficult to see how someone who was so impaired would be able to make the judgment that that a great bodily harm is about to happen to me and I must save my life, if he is that impaired from the blow to the head. And I don't think that this blow would have made any difference. They call it a sucker punch, but it could have been a blow, the first blow thrown in a fight face to face. And yes, you could also always receive damage, but you must have some kind of evidence of that damage. This doctor didn't find anything except in written testing. Nothing was found that was physical damage to show that there was some kind of injury. He opined you can have injury without showing any outward manifestation.
Should he opine that this impairment was approximately caused by this attack?
He tried to opine that, but he couldn't. I mean, under cross-examination, he first of all didn't test him until I don't know how long after this happened. All he did was say, well, my records reflect that, or the medical records reflect that he had prior injuries and they had resolved, or the doctors who saw him state that they had resolved to a certain extent. Now when I see him and test him later, he seems to have some injury to his head. And we don't know, again, before he drove off to the Waffle House, whether or not a crowd attacked him. I mean, we don't have any record facts to show that, and no doctor testimony to show that this happened as a result of that one blow. He cannot say that. Therefore, the judge looked at all the other evidence to try to piece together whether or not there is evidence that that blow really caused significant damage. There was none. This was a fist fight. He was not getting the best of it. He pulled out a knife, stabbed him 7 or 8 or 9 times, and at some point drove himself away and went to the Waffle House to get something to eat. I don't see how that's a basis for reversal. I think the judge made a finding based upon all of the facts that were presented to him. And if there are no other questions,
I know that the issues were presented to the judge in a sort of hyper-technical way. I mean, the argument was, if you find that there was a head injury related to this incident, then great bodily force was used against the defendant, and therefore the defendant could have used bodily force in response. So that's the way it was tried. That's the way it was presented. That was the way it was argued. Is that necessarily true? I mean, why would the defense have to prove a head injury? I mean, I've seen cases in 7th, 2nd, fairly recent ones where, one punch to somebody in a fight resulted in death, and therefore the issue on appeal was whether the manslaughter conviction was appropriate or not. I mean, so we know that a fist can cause deadly injury. There's no question about that. Why is this hyper-technical kind of evidence even necessary? Shouldn't the issue have been argued differently? I don't know that it makes a difference on appeal, but in other words, the law that existed before the legislature enacted its new self-defense statute required that in a mutual combat situation, as I understand it, the evidence was that most of the evidence, the judge wasn't asked to make findings about this because of the way it was presented, but the evidence was that, or there was evidence that these guys decided to take it outside and go fight. So they were going outside to fight. And under that context, as I understand the case law, you can't claim self-defense unless you retreat away from a fight that you voluntarily entered, if you voluntarily entered in mutual combat. So it seems to me that the issue should have been, did the guy have an opportunity to retreat? And if he did and didn't take it, he could not use deadly force. But if somebody just attacks you with fists and is coming at you and beating you to a pulp, I don't know why you have to prove a head injury before you can use deadly force if that's the only avenue available to you to stop the beating. Does that make sense at all?
Well, to a certain extent, I agree as far as these boys both agreed to fight. This was almost like, we're going to walk outside to do it so we don't mess anything up in here, and we're going to sit and fight. Now, at some point, I also agree with you that I think that he had to retreat or to stay down on the ground. All the testimony that I noticed in here was that when he went down with that sucker punch, he came back up, and he, in various ways, engaged in the fight instead of retreating or instead of backing down or staying down. That's the testimony. And I don't think it's necessary to prove a head injury. They were trying to elevate it to a great bodily harm, I believe, and in order that they could use the deadly force. I don't think it's necessary. I think self-defense was the issue, and I think self-defense could have been determined based on these facts, but it was easier for them to do it if we felt that there was great bodily harm and therefore elevated it to able to use a weapon. If your life is in danger, I think that's when you can reach for a weapon. And I don't see it under the facts, the witnesses in this case, that a life was in danger, except for the victim who was stabbed 7 or 8 times. Okay. All right. Well, if there are no other questions, I ask the court to affirm. Thank you.
Thank you. In reality, based on the record that we have in this case, the only issue for appeal is the deliberations of the trial judge.
Let me ask you a question. Was this a bench trial?
Yes.
Under the law, doesn't a fact finder have a right to disregard the testimony of an expert?
Absolutely. But that's
And by disregarding the expert's testimony, use its own common sense in reaching a decision?
true, but that isn't what happened. The judge specifically in this case found that the expert to be a well-schooled, very qualified expert, and he never challenged the expert's opinion directly like that. Instead, he substituted his own opinion. And it wasn't limited to just his opinion that you would require redness or swelling or bleeding for a closed head injury. He went on in his deliberations and said, from the record, now in car accidents, certain flexion extension injuries have been known to cause a brain damage, sometimes even without an impact. He renders that in his opinion, it seemed to him that it was reasonable that a person that you would expect to see some outside manifestation of brain injury. We know that brain injury cases are complex. That's why we require expert testimony with regard to proving or disproving those injuries. But in this case, the trial judge substituted, based on his own personal injury experience, his own opinion, in essence serving as an expert for the state. He went on, and he said on the same page.
But why isn't this common sense? I mean, I've copied the 5 pages of findings of fact that the judge made in rejecting the expert's opinion. And in the portion of that you're talking about, he goes on to say, this is common sense to me. I know that you can have a head injury without any impact, so with no external signs. But if, as in this case, you're going to have a head injury from a blunt force trauma, blow to the head, it makes sense to me that it would be more likely that you would have a head injury if you had a physical manifestation, because the harder the blow, the more likely you're going to have an external sign of the injury, and the harder the blow, the more likely you're going to have brain damage. Why isn't that common sense?
The proof is in his next statement, where he says, I don't see how you can get hit in the back of the head and have an injury to the front of your brain. We provided the court with 2 websites showing the medical scientific evidence that Dr. Foudy testified to. It's called a contra coup injury, that if you have a blow to one portion of the head, the scientific evidence shows that the injury should be on the other portion of the head. But the trial judge says, that doesn't make sense to me.
Thank you, sir. You've exhausted your time.
Thank you.